Muito boa tarde, muito bom dia, senhoras, senhores. Sejam todas as pessoas bem-vindas a este quarto encontro, Seminário Internacional de Direito e Religião da Faculdade de Direito de Ribeirão Preto da Universidade de São Paulo. Um tema Direito, Religião e Ambiente, político-cultural, coordenado pelo professor Márcio Pontilaco, professor do Departamento de Filosofia do Direito e Disciplinas Básicas da nossa faculdade, vice-diretor, quem eu cumprimento muito especialmente, agradeço, parabenizo por esta iniciativa e por toda a liderança, e todos os bons frutos que tem propiciado a nossa faculdade em decorrência da sua dedicação à causa acadêmica. E também cumprimentar muito especialmente o professor Dr. Rodrigo Vitorino Souza Alves, da Universidade Federal de Uberlândia, parceiro, professor parceiro, universidade parceira nossa, nesta iniciativa que é tão importante, uma parceria esta que é imprescindível para que possamos levar estas pesquisas e realizar eventos da excelência desse que iniciamos hoje. Desejo a todas um bom evento, espero que possamos seguir juntos no desenvolvimento dessas pesquisas.
Muito obrigado, professor Nuno, pela sua presença aqui conosco. Esse quarto seminário de Direito e Religião tem um escopo bastante preciso. O título Direito, Religião e Ambiente Político-Cultural. Quando nós escolhemos o tema, não tínhamos ainda a noção da inserção no atual contexto. Trata-se de um tema extremamente importante para a academia, porque nos toca a todos, nos atinge a todos, e especialmente no contexto latino-americano e brasileiro. O objetivo geral desse nosso evento é discutir a liberdade de crença e religião em seus desafios e perspectivas sociopolíticas, no âmbito do direito e religião, em suas diversas dimensões, como direito de expressão, de associação, de culto e de manifestação pública. Quero agradecer ao professor Rodrigo Vitorino de Souza Alves, que é parceiro já da gente, junto com o CEDIR, o Centro Brasileiro de Estudos em Direito e Religião, sediado na Universidade Federal de Uberlândia. O professor Rodrigo é também um expoente nesse campo, junto com um grupo que ele lidera, que é associado ao CEDIR, do qual eu tenho a honra de participar também. E nós, já é o segundo evento que fazemos juntos, né, Rodrigo? Já é o segundo evento, segundo seminário. Todos os seminários repercutiram e tiveram seus anais publicados, estão tanto no CEDIR, os que foram em parceria, como também no site da Faculdade de Ribeirão Preto e na biblioteca da USP, são de livre acesso. E a gente espera continuar nessa mesma perspectiva. Agradecemos aos participantes, aos ouvintes, à equipe de apoio, que tem feito um trabalho maravilhoso, tanto da informática como do setor de comunicação da faculdade. Aquelas pessoas que enviaram seus trabalhos, que terão ensejo hoje à tarde de apresentá-los, e também quero dizer do nosso contentamento com os expoentes, né? Todos aceitaram, todos foram unânimes, as mesas compostas, temos a conferência inaugural, logo mais, às 10 horas, cujo anfitrião será o professor Rodrigo, mediador, e depois, na sequência, os grupos de trabalho à tarde. Amanhã teremos duas mesas, uma de conotação plurirreligiosa, e que vai analisar o contexto sociopolítico e suas reverberações no direito, e uma com especialistas no campo do direito e religião do Brasil e da América Latina. E amanhã essas duas mesas, e na sexta nós teremos a conferência de clausura pela Jacqueline Niu, da Universidade de Singapura. Então temos grandes nomes, pessoas que vão colaborar efetivamente, embora um seminário mais enxuto, mas com conteúdo bastante incisivo no contexto em que estamos vivendo. Muito obrigado a todos. Passo a palavra ao professor Rodrigo Vitorino.
Muito obrigado, professor Márcio Ponzilacqua e professor Nuno Coelho pelo convite para participar aqui mais uma vez deste evento. Para mim é uma honra, professor Nuno, podermos colaborar com a Faculdade de Direito de Ribeirão Preto, da Universidade de São Paulo, nesta ação, e temos estreitado os relacionamentos. Já temos uma proximidade geográfica, né, entre a Universidade Federal de Uberlândia e a Faculdade de Direito em Ribeirão Preto, e nos últimos anos temos estreitado também esse bom relacionamento, né, especialmente por meio aqui dessa série de seminários que o professor Márcio Ponzilacqua tem organizado de maneira tão brilhante ao longo de todos esses anos, e um evento que tem se consolidado como um dos grandes eventos sobre essa temática no Brasil, né? E nesta quarta edição, assim como nas edições anteriores também, com uma inserção internacional muito importante, né? Considerando especialmente neste evento, que teremos a presença do professor Mark Hill, também ali do Reino Unido, e também a professora Jacqueline Neal, da Universidade de Singapura. Então, o professor Márcio tem sido, de fato, o grande líder deste evento e tem ajudado a consolidar essa área, que é o direito e religião, aqui no Brasil. É uma área relativamente nova, porque temos pouca produção bibliográfica em comparação com outras áreas do direito. Quando olhamos para o ambiente internacional, vemos que há uma produção mais ampla, há muitas obras publicadas em inglês. Na Espanha, por exemplo, já é uma área consolidada há muitos anos, com centros especializados, dezenas e dezenas de professores, ou centenas de professores que atuam nessa temática também, assim como em alguns outros países. E no Brasil, o professor Márcio tem contribuído de maneira decisiva para a construção deste campo, inclusive e especialmente por meio das publicações, sejam os anais, que são publicados após os eventos, e também outras obras que o professor Márcio tem conduzido, né, tem editado, tem coordenado. Então, é uma grande satisfação podermos ter essa colaboração, e fico muito contente também de ver a participação de pessoas de diferentes partes do Brasil aqui neste evento em uma plataforma online. Então, essa possibilidade de realizarmos o evento na modalidade online tem sido bastante eficiente no sentido de viabilizar a participação de pessoas que de outra forma não estariam. Então, para mim é uma grande satisfação, uma honra para o CEDIRE também, né, integrar como parceiro deste evento, que é o Centro Brasileiro de Estudos em Direito e Religião. Nós começamos as nossas atividades no ano de 2012, né, e de lá para cá temos buscado fortalecer o relacionamento interinstitucional, e contamos com um corpo de pesquisadores que integram, e de instituições que são parceiras, que tornam este centro também uma referência hoje para os temas que temos discutido. Então, é uma satisfação, parabenizo a Faculdade de Direito de Ribeirão Preto, da Universidade de São Paulo, pela iniciativa, e desejo um excelente evento a todas as pessoas que estarão conosco, porque trata-se de uma temática relevante para pessoas não apenas das mais diversas comunidades religiosas que compõem o nosso país, as lideranças religiosas que compõem o nosso país, mas especialmente para a comunidade acadêmica. Temos aqui um evento profundamente acadêmico que discute com seriedade os temas que são propostos, temas que são muitas vezes controversos, temas que estão atualmente no foco de parte dos grandes debates nacionais que temos todos presenciado. Então, certamente, este evento tem muito a contribuir para o avanço das discussões acadêmicas em nosso país sobre a temática das relações entre Estado, sociedade, direito, religião, crenças, temas complexos e que, portanto, merecem o lugar e o enfoque que este evento proporciona. Então, tenhamos um excelente evento, professor Márcio e professor Nuno Coelho.
Muito obrigado, Rodrigo, muito obrigado, Nuno. E a todos nós desejamos um excelente evento e temos certeza que os conteúdos que serão apresentados são de grande importância e também de acuidade, ou seja, tem profundidade, tem substância. E a todos, então, um bom dia. E daqui a pouco nós nos encontramos para a conferência inaugural. Até mais.
Olá, muito bom dia. Dando sequência ao evento organizado pela Faculdade de Direito de Ribeirão Preto, da Universidade de São Paulo, sob a coordenação do meu querido colega, professor Márcio Ponzilacqua, nós damos seguimento, então, a este que é o 4º Seminário Internacional sobre Direito e Religião. E hoje temos aqui a ilustre presença do professor Mark Hill, e eu farei a apresentação do professor Mark aqui, inicialmente em língua inglesa e depois em língua portuguesa. Professor Mark, it's a great pleasure to have you here with us in this event organized by the School of Law of Ribeirão Preto of the University of São Paulo. And it is with great joy that I will present you to our participants. Professor Mark Hill, QC, he is a specialist in ecclesiastical law, religious liberty, judicial review, and costs. Broad common law practice with emphasis since taking silk in 2009 on litigation concerning faith communities, Anglican, Catholic, Muslim, Jewish, Sikh, Hindu, and Baha'i. He's a lecturer at the Open University School of Law, visiting professor and distinguished fellow at Notre Dame University, London Law Program. He's also associate professor at the Center for Law and Religion of Cardiff University, King's College London, Pretoria University, and Notre Dame University, Sydney. Professor Mark is distinguished fellow at Emory University, Atlanta, a consultant editor of the Ecclesiastical Law Journal, and member of the editorial board of the Oxford Journal for Law and Religion. He is co-author of amicus briefs in the United States Supreme Court in various appeals, including Masterpiece Cake Shop in 2018 and Burwell versus Hobby Lobby in 2014. He's a regular lecturing overseas on the rule of law and religious liberty in projects organized by the United Nations High Commission on Human Rights and OSCE's Office for Democratic Institutions and Human Rights, including training for judges and lawyers in Uzbekistan, Nigeria, Kyrgyzstan, Myanmar, Taiwan, and Ukraine. In August 2019, he was installed as Chief Bameto of Erimo Land in recognition of services to freedom of religion in Nigeria. Professor Mark is Vice President of the International Consortium for Law and Religion Studies, former President of the European Consortium for Church and State Research, and member of the Steering Committee of the African Consortium for Law and Religion Studies. Mark Hill QC is one of the leading scholars globally on the field of law and religion, and a very dear friend of mine. Now, I will just make a short introduction in Portuguese. Professor Mark Hill é especialista em direito eclesiástico, liberdade religiosa, revisão judicial. Ele possui ampla experiência de litigância como barrister no direito comum, tendo sido agraciado com o título de Queen's Counsel em 2009, tornando-se recentemente King's Counsel. O título é concedido a um número muito limitado de advogados sêniores, que são selecionados por um painel independente no Reino Unido, devido ao seu conhecimento, experiência e habilidade. Atua em litígios relativos a variadas comunidades religiosas e desempenha funções docentes e de pesquisa em diferentes instituições, incluindo a Universidade de Notre Dame, King's College, Universidade de Pretoria, de Cardiff e de Emory, nos Estados Unidos. É membro do conselho editorial do periódico Oxford Journal for Law and Religion e do outro periódico Ecclesiastical Law Journal. O professor Mark tem sido coautor de manifestações como amicus curiae em diferentes casos, incluindo-se perante a Suprema Corte dos Estados Unidos. é conferencista internacional no tema do direito e religião, atuando em projetos do Alto Comissariado para os Direitos Humanos das Nações Unidas, para a Organização da Segurança e Cooperação na Europa, para o seu escritório de direitos humanos, e atuando em capacitações para juízes em diferentes partes do mundo, incluindo Uzbequistão, Nigéria, Quirguistão, Mianmar, Taiwan e Ucrânia. O professor Mark é também o vice-presidente de uma instituição de pesquisa da qual tem a honra de participar do conselho diretor, que é o Consórcio Internacional para Estudos de Direito e Religião, e também do Consórcio Europeu e do Consórcio Africano com a mesma temática. O professor Mark Hill, QC, é um dos principais estudiosos globalmente no campo do direito e da religião e um amigo muito querido. Professor Mark Hill, it's an honor to have you here with us, and the floor is yours. Thank you very much.
Well, I want to begin by expressing my personal thanks to Professor Rodrigo Vitorino Alves for his warm and generous welcome. He's been a friend for many years. I have been privileged to visit him and his institute in Uberlândia. And in the course of the last few months, we've had the pleasure of meeting in Rome in July and in Cordoba in Spain in September. And one of the sadnesses of today's meeting is that it's not in person where we can enjoy fellowship one with another, but it's across the screen. So I say good afternoon to you from the Temple in London, where I live and work, mindful that it's the morning for where you are all meeting in Brazil. And I recall that on Friday of last week, I was welcoming a group of Brazilian judges who were visiting the Inner Temple as part of a familiarization course to learn more about the English legal system and the way in which common law judges in England operate. And we had a very useful engagement in the course of those conversations. And I shared with those Brazilian friends and colleagues something of my specialism in the world of law and religion, and in particular, religious liberty. And what became plain to me is that there are common problems which face us in Europe and in South America, and there are common solutions, but often the way of reaching those solutions can be rather different. Now, it wasn't plain to me until very late last week that I would be asked to join you today. And the subject I've been asked to speak about is civil liberties, human rights, and religion. And it seemed to me that the best way of addressing that very broad subject in what I think is the opening session of your conference over the next few days is to step back a little bit and to view the entire panorama in as broad and comprehensive a way as possible. I have the privilege of teaching at an American university, Notre Dame or Notre Dame, which has a London presence, and American students spend a semester or a year in London, choosing a variety of courses. Some choose commercial law and other specialist areas where the London financial world is brought into play. But some choose my subject, and that's the subject of international religious liberty. And in pulling together the syllabus for that class, which I have the pleasure of teaching, it's compelled me to think rather more deeply about civil liberties in general, about human rights as a subspecies of civil liberty, and about religion and its particular application in cases of this type. And so I thought I would spend half an hour or so this morning outlining the course syllabus which we follow and the way in which I have sought to break down that subject as a teaching mechanism for bright, intelligent law students who are interested in pursuing the area of practice in civil liberties, in human rights and religion. And as with every topic of this type, it is essential to begin by placing it within a key context by way of overview. And one needs to ask the fundamental question, which is, what is the value of freedom of religion? In society today, which is becoming increasingly more global, increasingly responsive to worldwide security concerns, and increasingly motivated by aspects of secularism, it could be argued that religion has lost its place. Religion has been displaced from civil society and been confined very much to the private sphere. And there are arguments which suggest, for example, that religion is a matter for one's private conscience. It's a matter that can be lived out in the home, in the domestic setting, in a place of worship where collectively people come together with a shared faith for liturgical doctrinal practice. But beyond that, in society as a whole, the argument might be that there is no longer a place for religion. And if there is, then that place should be narrow, carefully prescribed, and subject to governmental intervention. Now, I think that proposal represents an extreme view, but it may be part of a trajectory in which globally we are all engaged. Because undoubtedly, religion and faith still have a significant part to play within the society at large. And one only needs to look at the key components of civil society in order to understand and appreciate how important religion is in delivering essential component elements to the population. Many schools are of a religious flavor. They follow religious lines and they are organized in accordance with the religious faith. Hospitals and other forms of healthcare provision are not infrequently provided through the agency or with the cooperation of religious organizations. And all sorts of civil welfare bodies on a voluntary basis have their place in the society because they are provided by religious organizations and they are animated by religious principle. Feed the poor, clothe the poor, make sure the hungry receive sustenance, make sure people receive an appropriate education. All of those mantras have a basic doctrinal force behind them. And if we were to prohibit the operation of religious actors in the public square, then many of the basic social services upon which we rely would collapse and would no longer be available for individuals to enjoy. And I speak particularly in this instance from a United Kingdom perspective. I think as Rodrigo was introducing me, he referred very kindly to the letters that come after my name, and used QC. Well, of course, QC no longer applies. The letters QC refer to Queen's Counsel, a senior rank of practicing attorney, and a rank held by dint of the status of Her Majesty the Queen. Well, as is well known, she died a couple of months ago and was succeeded by King Charles. Hence, the letters after my name are now KC rather than QC. But I'm not the only person who's been affected by the death of the Queen and the accession to the throne of King Charles. It's had quite a significant impact in relation to how religion is viewed within the context of the United Kingdom generally and of England in particular. And the reason is this, that the Church of England, by historical accident, has a unique constitutional position within the framework of the United Kingdom. It is an established church. It is governed by primary legislation, and as a consequence, it has certain duties and certain privileges which attach to its nature of being established. One of those is the fact that bishops of the Church of England have the right and duty to sit in the House of Lords as part of the parliamentary structure and the legislative body which governs all lawmaking for the United Kingdom. And as I was returning to my office to give this presentation today, I learnt that His Majesty the King had appointed a new individual to fill the vacant episcopal position as Bishop of Liverpool. And I think it would be unheard of in most liberal democracies for an unelected head of state to nominate and appoint a religious leader who would then assume a seat in the secular government of the country. And although when I speak in international fora, it is suggested that there is something wrong and anomalous about having the type of constitutional relationship which I have just illustrated, there are others who reply that having a particular denomination with a very powerful link between the church itself on the one side and the state on the other is nonetheless important and significant, because it is an ever-present reminder of the importance and the significance of the sacred in society. And sometimes the argument is said, well, what do other faiths have to say about the Church of England having its leaders in a position of government? And the answer is simple and sometimes surprising. In this country, at least, Muslim leaders, Jewish leaders, and leaders of other Christian faiths are the most vocal of all individuals who are citizens of the United Kingdom in maintaining the status quo and continuing to have Church of England bishops exercising a right of leadership in secular government. And the argument is this: if they were to be removed, then in the current climate, it's unthinkable that they would be replaced by a cross-section of leaders representing other faiths or other Christian denominations. The reality is, if they were to be removed, then they would not be replaced at all. And that would have, so these other faith leaders say, a negative impact on the nature of British society and the way in which we are governed. Because their point is simply this, that by having Church of England bishops taking a seat in our parliament, it is a constant reminder to government at all levels and to civil society that there is an essential spiritual element to the way we live our lives that must always be borne in mind when the common good is under consideration and when legislation affecting the general population is under consideration. And I think that is why, for the foreseeable future at least, the constitutional settlement will remain. And of course, after having had 70 years under the consistent monarchy of Her late Majesty Queen Elizabeth, there might well be change and evolution now that King Charles III is on the throne. But he has made a number of significant public contributions to the question of faith in society generally. And he has made the point that although as a matter of constitutional law, dating back to the 16th century, the monarch is the head of the Church of England and is known as the defender of the faith, that in reality, his position is not merely to agitate for the well-being of the Church of England, but it is to ensure that people of all faiths and of none have their fundamental right to display and exhibit their faith as freely as possible. And on the very day that King Charles acceded to the throne, he spoke of the importance of upholding all faiths, and that was broadly to be welcomed by those across the board of every different colour and stripe, so far as their religious allegiance is concerned. So, having taken a very small snapshot of the current position here in England in the 21st century, it's of some value, I think, to look at freedom of religion through the lens of history and to see how it has developed from the time of the early Roman writers until today. Because for the most part, when people have spoken of freedom of religion, they have been speaking specifically of freedom of a particular faith, a particular sect, or a particular denomination. Through the window to my right is the Temple Church, an important 12th century structure where I've had the privilege of taking Rodrigo to visit on one of his times when he was with me in London. The building dates back to a time when the barons, who were the essential bankers for King John in his war with France and Northern Europe, and were financing his campaigns in those parts of the world, were brought to the negotiation table in order to discuss basic human rights. And the point was simply made to the king, first, that he was not above the law. The law applies to everyone, even the ruling monarch. And secondly, that even the monarch is answerable to God. And it was in the course of creating a bargain which allowed the barons and bankers to continue to fund King John's war, that the written compromise was drafted and executed at Runnymede on the banks of the Thames, one of many European charters of this time, sealed by King John in 1215, which set out the rights and obligations of the citizens and of their rulers. And this document came to be known as Magna Carta, the Great Charter, the charter that set out rights and obligations and fundamental principles. And in the opening paragraph of that Great Charter, executed in 1215, was the statement that the English Church shall be free, and the Latin expression Ecclesia Anglicana were the word used to talk about English church. Now, of course, that can't be translated into Church of England as we use in the modern idiom, but it is very much the church as it operated within England, that being the Catholic Church, the Latin Christian Church, under the authority of the Holy Father at the time. And there are many who read Magna Carta as a great constitutional document, one of the forerunners to the American Declaration of Independence, which was seen as having a fundamental effect in setting out the significance and importance of freedom of religion. But I think that's a slightly warped view of modern commentators, because at the time there was no suggestion that this would be freedom of religion for everybody, irrespective of the faith community to which they belonged. In reality, it was the freedom to be a Christian within the territory of England, and it certainly wasn't expansive, giving freedoms to Jews, to Muslims, and to others who may dissent from the Catholic faith. And even moving forward by several centuries into the Reformation, when Henry VIII passed domestic law, leading to the break with Rome and the creation of what duly became the Church of England, a Protestant church still adhering to Catholic doctrines, but under the leadership of a national monarch, not a supranational pope. Again, one spoke of the freedom to be an Anglican, the freedom to be part of this uniquely created church here in England, but not about the freedom to live under other types of faith community or religious group. And just as within the confines of England, that revolution was taking place, so in Europe, the Protestant Revolution was taking hold, and characters such as Martin Luther and John Calvin were in their respective cities and regions asserting freedom from the Catholic Church, but at the same time creating a restrictive obligation to follow a Protestant doctrine such as it was. And I think it's easy, looking back through the arc of history, to adopt a 21st century understanding of what freedom of religion truly meant, and not really to understand that the time in question, the freedom, was only in relation to the religious denomination of the governing class. And it was only very slowly, as the centuries passed, that one started to find an expansive freedom, allowing individuals of minority faiths the rights that were enjoyed by those in the majority. And the word that was used, it was used in the statutes, it was used in the commentary, was the word of toleration. And toleration, to my mind at least, has a significant number of very negative connotations, because toleration proceeds on the assumption that the majoritarian faith, which is dominant, is better and is of a superior quality to anything else. But for whatever reason, reasons of commerce, reasons of civil order, other minority faiths are merely accommodated. And that, to my mind, is not the giving of equal rights, but the giving of lesser rights, and the idea that one will endure the positions of others as they are seen. And toleration leads to accommodation. Accommodation, I think, is something slightly more generous than toleration. It involves a change, an alteration of the primary domestic law, allowing other religious organizations to flourish. But the substantive change, and it's a change of worldview that looked at, when the hindsight that we now have was groundbreaking, didn't truly emerge until the end of the Second World War and the creation of international binding treaties which sought to articulate fundamental rights, human rights, rights that are talked of as being inalienable, rights that are so much part of the core of one's being that they cannot be given up, they cannot be rejected, and they cannot be overridden. And I think a great deal of credit must be given to the authors of those international documents, people who had themselves endured the horrors of the Second World War and of genocide and of man's inhumanity to man, starting from the premise that they would create a better world where such atrocities will never be repeated. And so perhaps it's here that the headline topic of what I was asked to speak about in terms of civil liberties, human rights, and religion really comes to its zenith and most significant point, because we're talking with human rights in the terms of what is written in the Universal Declaration, in the International Covenant, in the Inter-American Convention, in the African Charter, and in all of those cumulative regional, pan-national documents to which governments signed up as part of their global treaties. It's there that we find the language of human rights set out clearly for all to understand. And I think civil liberties is a concept, it's not quite synonymous with human rights, but it's very similar. It's the idea that every citizen simply by their status as a citizen, has the right to do certain things, the right to be protected from certain things, and the right to live their lives as they would wish. And so there's this enormous cleavage which comes in the 1950s, and we talk about BC and AC, the Common Era. If one is really looking at there to be a dividing line, and the Common Era when it truly started, it's in the way we look at rights after the Second World War, as opposed to the way we looked at rights before that. And we see it in terms of man-made, treaty-based, black letter law rights written into these global treaties. On perhaps a lesser level, civil liberties as protected by national governments with domestic legislation and working in their own courts. And then we get the final word, the final element of the topic I was asked to speak about today, and that is religion. Because it seems to me, as someone who has spent 3 decades studying this material, that religion was never in the forefront of the mind of those who were drafting these significant international instruments. They spoke of the right to life, being free from torture. Those were the real gritty fundamentals that were absolutely essential. And in many ways, religion was seen as something of an add-on, not central, not part of the basic core of those rights, but a Cinderella subject, a borderline subject, or a marginal subject that was just added as an additional clause in each and all of those international instruments. And one can conduct a very useful exercise at this point by looking at the European Convention on Human Rights. And I must be candid, that's the treaty with which I, as a European, am most familiar. But if you look at that treaty, and if you look at how that treaty has been enforced by the European Court of Human Rights in Strasbourg, you'll see the history, and you'll see one very marked change which took place when the judgment was delivered by that court in 1993 in the case of Kokkinakis and Greece, an issue concerning what was said to be unlawful proselytism by 2 individuals, which was seen as being offensive to and dangerous to the prevailing Greek Orthodox Church. And the date is significant. The date is 1993, nearly 40 years since the 1950s, when this treaty was first brought into effect. And commentators have sought to discuss and argue as to why it took 40 years before the Strasbourg court was making a decision under Article 9, which is the provision of the European Convention that deals expressly with freedom of religion. And there are various arguments. Does it show the judges were not interested in freedom of religion? Does it show that in each of the member states of the Council of Europe, the domestic situation was perfectly happy and therefore there were no disaffected litigants? wanting to take their claims to Strasbourg? Or is there some other reason why religious claims didn't find themselves before the judges, first of the European Commission and then of the European Court of Human Rights? I think, on a proper analysis, the answer is rather more straightforward. If you look at the period from the 1950s to the 1990s, there were still a considerable number of religious-based cases which ultimately found their way to Strasbourg. What was interesting was that the judges did not need to decide those cases on the basis of Article 9, the freestanding freedom of religion provision. Some were decided on the basis of the right to a family life. That was construed broadly, and that was seen as sufficient to give to the litigants proper redress and satisfaction of their religious claim. Some were about meetings in places of worship and so on, where one didn't even need to engage the process of Article 9. One had another part of the convention which dealt with freedom of association. And others concerned blasphemy, hate speech, talk that was vile and offensive to religion. And again, the litigants didn't need to avail themselves of Article 9 and all that Article 9 says about freedom of religion, because there was another component part of the European Convention, and that was freedom of expression. And provided the judges were able to give to the applicants the declaration they required, the relief they required, and therefore the result was in their favor, they didn't need to go further and look specifically at Article 9, which has religion expressly written into its text. So the concept that the Strasbourg court said nothing on religion for 40 years until Kokkinakis raised its head is a false impression, and one that does no justice at all to the judicial activism of the Strasbourg court at that particular time. Because civil liberties are interconnected, and human rights are not freestanding individual provisions. On the contrary, human rights are carefully drafted to be an interlocking suite of rights which are self-supporting and which provide to citizens a powerful pushback against oppressive states to ensure that freedom can be lived out in a genuine and a real way. And I think there are two consequences that follow from that. And the first is, if one looks at freedom of religion as a narrow human right, the language used in most international instruments, and it's a language replicated insofar as freedom of association and freedom of speech are concerned, is that the right is broadly written and expressed in clear language, and the limitations are narrow, and the burden of proof is on the government to show that one or other narrow limitation applies. So the small man, the citizen, can claim a big right. The monolithic state needs to demonstrate that that right is curtailed and in some way limited by demonstrating to a high standard of proof what that negativity must be. And then I suppose one comes to the final point that I'd like to spend a moment or two developing. And that's because I speak of human rights as a composite suite, as a jigsaw, a patchwork, a multi-layered, multifaceted device of human construction, which has its own internal complexities. What happens when two rights are in collision? Where my right to express my religion conflicts with someone else's right of privacy. And one sees repeatedly in litigation in the 21st century that there is an evolving tension between sexual orientation on the one hand and religious liberty on the other. And in a case-by-case basis, judges throughout the world are being forced to decide which right will prevail against which other right. And if you read the European literature, there is an evolving impression that where all these rights are concerned, state officials and secular government consistently regards religion as a less significant right and the right that has to yield and give way where other rights are concerned. I'm yet to be convinced that that viewpoint is necessarily correct, having had the privilege of arguing cases in both domestic and international courts. I see judges genuinely struggling to maximize the rights of everyone concerned. But the trouble with all forms of litigation is that it is always a plaintiff against a defendant, a claimant and a respondent. Litigation has a binary concept to it, whereby a judge is given a stark choice. The claim either succeeds or it fails. You have a winner and a loser. And I suppose if I am in this opening session to make any contribution at all, it would be to urge experts in this field, academics, students, and others, only to resort to litigation as a last possible refuge, because the guiding light must always be to find workable compromises, sensible accommodations, which enable people to live together. I spoke on an earlier occasion at an event organized by Rodrigo about religious liberty in the workplace. And that is almost like a laboratory. In microcosm, one can see how various religions can be properly accommodated by being aware of what the needs are and what the limitations are, and being sensitive to the feelings of others. And I would argue that in pursuit of these sensible, local, informal accommodations, we are greatly assisted by what I regard as the newest international document. It doesn't have the force of the UN. It's not being signed up as a treaty by state governments, but it is gaining increasing traction among those who practice in this field and who write on the subject. And it is the Punta del Este Declaration on human dignity for everyone, everywhere. And I wonder whether for everything there is a season, and whether here we are in the 21st century, the season of rights, which were so important as we came out of the horrors of the Second World War, are now being overtaken with the season of duties, where we must be more aware of the duties we owe to our fellow citizens, to our planet even. And if by using the language and the construct of the Punta del Este Declaration, and by seeing human dignity as a goal, I imagine that we are going to be far more successful in the village, the town, the national government, and the pan-national situation. Because any resolution that holds back from the binary language of rights and instead presents the question of maximizing human dignity for everyone means that people will all be the beneficiaries. And it means people of religion, of course, will benefit, but people of religion will not be unfairly advantaged over those who are not of religion, because the concept of dignity is sufficiently broad to go beyond that. But I think I've probably covered enough ground already, and if you're still listening, thank you for your attention.
Professor Mark Hill, thank you very much for your presentation. It was brilliant. As you mentioned, it covered several issues, and you brought a historical perspective. I am just going, since we don't have simultaneous translation, I'm just going to make a short summary of the main points of your presentation, and then take a couple questions from the audience. Professor Mark Hill Professor Mark Hill fez a sua palestra sobre o tema das liberdades civis, direitos humanos e religião. Ele começa com os seus agradecimentos e cumprimentos, coloca que o exercício da religião e os seus desafios são questões comuns a várias sociedades contemporâneas e indaga qual é o valor da liberdade de religião ou crença no mundo contemporâneo. O professor Mark coloca o debate relativo ao valor da religião, se é matéria de relevância pública ou se diz respeito à consciência íntima, questões domésticas e do interior de templos religiosos. E, a partir disso, explora a temática da relevância pública das religiões, destacando o seu papel, por exemplo, na formação de escolas, hospitais e outras formas de promoção da educação, saúde, bem-estar, assistência, muitas dessas ações de base voluntarista e que são motivadas religiosamente. Proibir a atuação dos atores religiosos na esfera pública ou no espaço público de modo amplo causaria o colapso de muitos serviços que beneficiam a sociedade. O professor Mark, então, vai ao contexto britânico e inglês em particular, falando da especial posição da Igreja Anglicana ali na Constituição inglesa, né? É uma igreja estabelecida, governada pela legislação estatal primária e tem um papel especial em função dessa posição. Comenta, então, algumas particularidades do contexto inglês e britânico também, questões relativas à mudança na monarquia, agora com o rei Charles, e depois volta-se, a partir de um olhar histórico, para os principais documentos ingleses, especialmente a Magna Carta de 1215, que foi um precursor dos documentos constitucionais. Então, o professor Mark apresenta uma visão panorâmica de início, a proteção da liberdade da igreja, falando principalmente a partir da igreja inglesa, inicialmente católica, posteriormente independente do catolicismo romano e sujeita ao monarca inglês. fala também da expansão da reforma protestante e de como isso também impacta nessa configuração, uma vez que a liberdade da igreja agora passa a ser defendida pelas igrejas protestantes em particular. Discute o conceito de tolerância do Estado frente às comunidades religiosas, colocando que tolerância pelo Estado tem um caráter negativo, no sentido de que o Estado assume uma doutrina religiosa como sua e meramente tolera as demais. E observa-se uma mudança de paradigma, especialmente após a Segunda Guerra Mundial, com a afirmação da liberdade religiosa nos documentos internacionais, especialmente a partir da Declaração Universal dos Direitos Humanos. Comenta a jurisprudência específica da Corte Europeia de Direitos Humanos, o caso Kokkinakis contra Grécia, sendo o primeiro caso, embora o tema da religião encontrasse lugar em outras discussões anteriores sobre liberdade de associação, direito de família e liberdade de expressão. O professor Mark, então, já a título de considerações finais, ressalta a complexidade dos direitos humanos, as suas variadas camadas e os problemas relativos às tensões entre os direitos humanos. E conclui reforçando que sobre a ênfase dos deveres, especialmente no dever de respeito pela dignidade humana, com especial destaque a Declaração de Punta del Este sobre a dignidade humana, que ressalta a linguagem dos deveres como uma linguagem em ascensão, assim como as décadas passadas viram o fortalecimento da linguagem dos direitos, agora é importante uma mudança de perspectiva para se enfatizar também a linguagem dos deveres, em especial o dever de se respeitar a dignidade da pessoa humana. Nós temos alguns comentários, perguntas. Em função do horário, eu vou apenas destacar aqui 3 considerações que foram feitas. Eu vou falar em inglês para o professor Mark, porque todos já viram estas anotações nos comentários. Professor Mark, we have a couple of comments and questions, and I'll take just one comment and 2 questions, so you can also consider and comment from your perspectives on the topics. So the first one was a comment by Aline Miot. She said that uniting knowledge, as suggested by Edgar Morin, every religion, in spite of political manipulation, in accordance to Carl Jung, is an attempt of connecting the sacred, of connecting ourselves with the sacred. And that's the reason why it should be respected. So that was her comment. And it was probably when you mentioned the importance of the Anglican Church in the Parliament as representing religions in the political sphere of the UK. And there are 2 questions by Cristiano Tenorio. The first one, how religion can influence the behavior of people, and what is the limit between the exercise of religion and the abuse of human rights, or abuse of freedom of expression, or violation of the rights of others. So on the limits of the exercise of freedom of religion or belief. And the second question is how different cultures and religions meet their point of balance, of equilibrium and communication among the different peoples and nations. So the problem of cultural and religious diversity and how to reach common ground or balance or equilibrium in this diversity of cultures in the international sphere, the diversity of religions as well. So thank you very much, Aline and Cristiano. And now please, Professor Mark.
Well, first of all, Rodrigo, you had my admiration that something that took me 45 minutes to deliver, you summarized in 4. So your skills are absolutely remarkable. I don't think I fully heard or understood the first comment. So if you need me to respond to it, you'll have to rephrase and come back a second time. While you're thinking about that, I can deal with the 2 particular questions you did ask to the extent that I fully understood them. And the first, I think, related to limits of behavior. How far should we allow things to extend? And I suppose the starting point really here is where one's background is. I see myself as an arch libertarian, and I would look for maximum freedom and minimum restraint. I would believe in placing trust in citizens to self-regulate rather than having a top-down repressive state regime that sought to impose limitations in a variety of circumstances. And I think I would also argue that religions, particularly majoritarian religions, need to be relatively robust. From my vantage point, there is no right not to be offended. I think I go out in the street and I don't expect, but I will tolerate abusive language being directed at me to the extent that that's the freedom of expression of others. And I would rather hear unpalatable and unpleasant things than support a state regime which suppress those. The margin, I think, is crossed when offensive speech becomes incitement to physical violence, which impacts and harms individuals. So I hope, although I've spoken fairly briefly, that gives a broad view of where I imagine the limitation should be. But I will consistently argue for maximizing freedoms and minimizing limitations. Now, the second question, if I've understood it correctly, is fascinating, and I'm delighted it's been raised, about where we find an equilibrium and where in different cultures we end up in terms of freedoms and so on. And let me make something absolutely plain. In speaking with approval of the English situation with an established church, I am not arguing that that is the paradigm or the model that should be adopted. On the contrary, on its face, it's a wholly inappropriate model that runs contrary to our basic understandings of freedom. But it has been developed over time, by which I mean over centuries, and it works for us in our situation where we are. I wouldn't for a moment advocate it as a starting point. As you say, it's about evolving to an equilibrium, and that is the position where we've evolved. And only by understanding our past do you see where the present is. Now, I think it's fair to say that the language of human rights and the language of religious liberty has been dominated for too long by Western ideals and by concepts, post-colonial concepts from Europe and from North America. My most recent project, led by Professor Silvio Ferrari of University of Milan in Italy, was to look at a global view of religious liberty, resulting in the Routledge Handbook. And we detected severe shortcomings in the global literature, in that there was very little on Asia, very little on Africa, and even South America was underrepresented in terms of its geographical and population sizes. And I think we need, in the next decade, to redress and recenter where our discussions are of freedom of religion, taking seriously into account cultures outside Europe and outside North America, and religious identities beyond the Christian and the Abrahamic. Because the work I've done over 15 years as one of the leaders of the African Consortium of Law and Religion Studies has convinced me that we in the West have far more to learn from the experience of Africa than we could ever teach the Africans in terms of symposia and projects and otherwise. I think in terms of living together, in terms of finding communitarian resolutions for real issues, Africa can teach us a great deal. The idea that a village will find a resolution, a family will find a resolution, or a region will find a resolution, acting informally, collaboratively, and consensually, could, I think, provide a really meaningful model for the West, where we are far too reliant on cases being taken to litigation or on imposing an external arbitrator or a mediator. And so I actively encourage the study of different cultures and the involvement of different cultures in the scholarly community which is emerging. And it's certainly one of my primary objectives as the Vice President of the International Consortium for Law and Religion Studies, to make sure that that consortium is as international as it possibly can be, and to make sure that underrepresented voices from certain parts of the world are heard loudly and clearly in the decade ahead.
Thank you very much, Professor Mark, for your comments on the questions posed by the audience. I am very happy that we had this opportunity to listen to you. I know that your time is very limited, and we don't want to hold you longer than you were able to stay. So thank you very much for accepting the invitation of the organizers to be here at this panel. And we are hoping to have you in Brazil very soon, in person. So we'll keep in touch on that. I would like to thank all the participants for staying here and for participating in this event. And I would like also to invite Professor Marcio Ponzilacqua, to say the final words. And well, again, thank you, Professor Marta, and thank you, Marcio, for the invitation to be the moderator of this panel.
Professor Mark Hill, very grateful for the excellent lecture. He illustrated us deeply. It's an honor to have you with us. We look forward to having you in person on another occasion. Professor Rodrigo, muito agradecido também pelo esforço, pelo empenho de tradução, pela síntese que você fez. Então, thank you very much, Professor Rodrigo, for the very good synthesis and for the generous work of translation. A todos os presentes, nós agradecemos muito esse momento, que foi bastante rico para todos nós. Esperamos contar com o professor Mark Hill noutra ocasião, pessoalmente, presencialmente. E já começamos bem o nosso seminário, né? Com essa excelente conferência de abertura e que nos ilustrou muito, não só o contexto inglês, mas a própria discussão do direito e religião. A todos uma boa tarde. Nos encontramos com aqueles que se inscreveram nos trabalhos hoje à tarde, às 12h30, e amanhã, às 8h30 da manhã, nós temos a primeira mesa de debates do evento, e à tarde, também às 12h30, se não me engano, é só seguir os links que foram enviados para todos, a segunda mesa, e todas muito interessantes. E a conferência de clausura, de encerramento, com a professora Jacqueline, na quinta-feira, às 8h30 também. A todos, muito obrigado. Thank you, Professor. Thank you.
Thank you very much.